Welcome viewers, Dr. Rashid from Islamabad Policy Research Institute. Today we'll discuss Indus Water Treaty and its several aspects as it impacts the regional security dynamics and water security of Pakistan. We have with us our law chair, Ms. Maham. And jumping straight away to the first question, India is holding the Indus Water Treaty in abeyance illegally, and this is an act which has drawn flag from the international community as well as the international law organizations. What do you think a country like India can it countenance this international opprobrium and retribution by so flagrantly violating our treaty, which was brokered by the World Bank?
So, sir, that's a very good question. And at the outset, it's very important to clarify that there's no such thing as abeyance in the Indus Water Treaty, because there's a lot of confusion that is it set aside, is it abeyance? Sir, the Indus Water Treaty particularly states that the treaty can only be modified or terminated. And these are the exact two phrases that are used by another treaty concluded for that purposes between the two governments. So Article 12 is very, very clear on that. There's no gray area about it. So any unilateral act such as what India has done to hold it, say, in abeyance is completely violative of the treaty, because the treaty does not allow for it. And in international law, sir, when there's a bilateral agreement that specifically administers the laws particular to a relationship, then you cannot step out of this treaty. So when we talk about what is the cost to India of it, or what India has done, firstly, sir, there's the concept of internationally wrongful acts. There's an internationally wrongful act instrument as well that says that states, when they commit such an act, which is stepping away from an international obligation as well, they can then be coerced into abiding by that. So how is that coercion going to take place, sir? And there's a lot of talk about it, and it should be clarified that there's this concept of countermeasures in international law. So countermeasures are not really retributive in nature. So the idea of countermeasures is not that, oh, you are going to punish them. But the idea of countermeasures is the fact that you will use the instruments at your disposal to compel one party to abide by its obligations. And how does that happen, sir? In the past, countries have used economic sanctions as countermeasures. Countries have used closing airspace as countermeasures. The important thing about countermeasures is that they allow countries to do something that they would otherwise not be allowed to do, but then it becomes legal to do just as a means of forcing the other party to abide by its own obligations. So, for instance, sir, if we close off airspace, which we've seen Pakistan and India both do in times, that is in violation of the Chicago Convention, which is administered by the International Civil Aviation Organization. But, sir, then Pakistan, it becomes allowable to do so because if a country steps out of one obligation, then it allows another country to act that. But sir, the important thing is that you can only use countermeasures with the intention of ensuring compliance. It cannot be a retributive act. Another thing that is important in international law is compensation and reparation. Compensation and reparation is the fact that there are times when some harm has been committed, and then you can go to international courts and tribunals and ask for reparation and compensation, because there's no other way to rectify the harm. So for instance, if there is damage that has caused irreparable harm to the soil in Pakistan because of changed water flows, then there are situations where compensation and reparation become possible.
Thank you very much. Very good answer, Maham. It leads us to another issue, and that is the development of an entire corpus of international law regime related to water law post 1960 treaty. Now, there's a school of thought that believes, rightly perhaps, that the entire regime that has evolved, it does not secure the rights of lower riparians as much as it helps the upper riparian, especially once we compare it to a bilateral treaty like Indus Water Treaty, because Indus Water Treaty very clearly protects, guarantees the rights of a lower riparian, that is Pakistan. And there are voices that say that, okay, what if we go out of Indus Water Treaty? There's still international law. So I would like to pick your brain on this. What's your opinion on this issue that India wishes to talk out of Indus Water Treaty and Pakistan wishes to remain engaged and discuss our mutual issues within the framework of the treaty?
Thank you for that question. So, the important thing to realize is at the outset that when there is a bilateral treaty, it surpasses any general principles of international law that may or may not exist in that particular region. And the Indus Water Treaty particularly was negotiated for 9 years, and the idea was to very delicately balance the technical requirements while at the same time the legal requirements and the water requirements of both the upper and lower riparians. So the Indus Water Treaty in itself is a very comprehensive legal instrument that allows for water division according to the needs of both countries. When we talk about international water law, which has evolved post the 1960, the governing convention on international water law is the 1997 convention.
True.
And the question whether the 1997 convention protects the rights of lower riparians is debatable, because the 1997 convention does not just talk about one provision. It talks about the main provisions would be the reasonable and equitable utilization principle, the obligation not to cause significant harm. So the important thing to realize is that when people talk about the convention, they pick one principle and say, oh, this is not very favorable to upper riparians or lower riparians, but if you look at the convention as a whole, you realize that the convention balances the rights of not upper lower riparians, but in a lot of states, transboundary waters are shared by multiple states. So it has a balancing act within it, which becomes obvious when the entire convention is applied to a particular situation. It's important to realize that neither Pakistan nor India have signed the 1997 convention. So, although some of the principles are part of customary international law, the convention is not binding on either party. In the absence of that binding governing convention on water law, the Indus Water Treaty remains the absolute instrument to look towards for any water issues that come. And more importantly, the Water Convention now embodies a principle called the Community of Interest Principle. And the Community of Interest Principle says that a water body needs to be shared in a way that the community of all interested parties are protected. So the idea is that the confusion comes when you take the convention in bits and pieces as opposed to looking at the whole of it. But again, a bilateral particular treaty will surpass any general principles.
Thank you. A very comprehensive answer, and it leads me to segue into the conflict domain, because if this international law regime that is not as strong as a bilateral treaty like Indus Water Treaty, could you recall any international conflicts between upper and lower riparians that have led to conflicts?
Definitely, because the conflicts over shared waters has been part of history since time immemorial, and some countries have been able to solve those conflicts by very, very strong agreements, while other countries, say we see in the Euphrates-Tigris River example, are still there's still issues with that because a strong governing document on the water sharing arrangement has not been created. The conflict that comes to mind most most significantly right now is the Ethiopia-Egypt issue over the Nile River basin. So interestingly, Egypt is the lower riparian and Ethiopia is the upper riparian, but there's a significant imbalance between their political powers. So that's a particularly interesting case to see also, because there's the time when we see a lower riparian exerting more political influence than the upper one. But nonetheless, Ethiopia started building the Renaissance Dam, and although the Nile Cooperative Agreement, multiple versions of it have come on board at multiple times, the shortfall of that is that it does not take into account all riparians of the Nile. And so that's kind of seen as an incomplete agreement. So Ethiopia, Nile is one thing, and both countries, Egypt has on multiple occasions said that if the dam continues to impact the water flow into the lower riparian, which is Egypt, they are willing to escalate it to a higher level. Then prior to, we've also even seen it in the developed world like North America with the Colorado River. So, the US-Mexico treaty, before it was signed, there were a lot of border issues with that. But they were sensible enough to sign the US-Mexico treaty that has ensured the, so that particular one is important also because they've ensured the sustainable development of the resource so that it remains available for the generations to come.
So the importance of bilateral treaty is highlighted.
Yep.
Now, how about the latest Court of Arbitration award? Has it vindicated Pakistan's stance on Indus Water Treaty?
Definitely. So it's important to understand that there have been 3 awards. The first was the award on jurisdiction, whether the court has jurisdiction or not in the situation where India has boycotted the proceedings, where the court decided that it has jurisdiction. The second was the unilateral holding of abeyance of the treaty by India, in which the court again decided that this abeyance, because the treaty does not allow for it, has no material impact on the court's proceedings and they will continue. That means that's the most important one in my opinion, because what that did is that it said that the abeyance notwithstanding meant that they will still continue to operate under the dispute resolution mechanism of the treaty, which means that for them the treaty is legally binding, because you can't operate under a mechanism if the treaty is no longer binding. So that's the second one. And the third one was where the court gave its supplemental award, and that's important for Pakistan as well, because the court spoke about the level of pondage and spillway gates and about how the interpretational differences between Pakistan and India, and how moving forward the Court of Arbitration and neutral expert both have jurisdiction to deal with it, and both decisions, which is important to understand, will be binding for future disputes. How that helps Pakistan is that Pakistan's always been in favor of resolving one dispute and going on to another thing. So the precedential value that has been set by the court, that no, once something's decided, future courts and neutral experts will abide with that, has a lot of value for Pakistan, because Pakistan's always had that thought process.
And the neutral experts' decision, presidential value of that would be applicable to the particular project, not to the new project. That is also something very important, and I think it favors Pakistan's stance.
It would be applicable to the particular project, but if the neutral expert has clarified or interpreted the treaty, then that clarification and interpretation will also be applicable to future projects, so that you don't keep on litigating. For instance, the pondage question is an issue. Once it's decided, that will remain decided for the future projects as well. So that gives a lot of clarity for both countries when they're designing their future projects as well.
Okay. We know that India's position is grounded in allowing the changes in design features so as to enable them to have a certain level of pondage and low intake gates to ensure that they have this better silt control so that their dams do not silt up.
Yeah.
And Pakistan's position is rooted in strict adherence to the design parameters as enshrined in the treaty, so that India does not develop a capacity to be able to manipulate. Pakistan doesn't care. They have pondage for their own non-consumptive and irrigation uses, which permits them to have a certain use of waters. For instance, India has a right for 3.6 MAF storage and 1.3 million acres of irrigation. They haven't come close to even that, but it is that manipulable capability that they can, in the lean periods without water and in periods of plenty like monsoons, use that water probably for flooding. So that is the issue that rankles and that creates this acrimony. So what do you say is the reconcilable position between these two extremes?
The reconcilable position is to adhere to the treaty, which has always been Pakistan's stance, is the fact that all of these situations, or most of them, were taken into account. If we see the negotiating history of the treaty, all of these things were taken into account when the treaty was being negotiated. And a bit about the negotiating history of the treaty. It took 9 years to do that. The World Bank was involved. Very high-level engineers from both countries were involved. So the delicate, the important thing to realize is, what people don't think is that the Indus Water Treaty, while it is an engineering treaty, because if we've read it, we can see it's very dense with engineering concept, it is also a compromise of the legal right and engineering concepts. So when such a treaty is created that balances the law and the engineering design aspects, it has to be realized that both countries have to give and take in that. Abiding by the treaty right now is the best course of action to narrow that gap. I'm not saying that doesn't mean that issues will come up with regards to the design capacity, also particularly in times when newer design models are coming up for water storage as well. But the treaty provides for a mechanism to address those. There is the Permanent Indus Commission. You can go to the neutral expert. If you see the questions that the neutral expert can deal with in Annexure F of the treaty, they almost take care of everything, including newer issues that newer design concepts, the neutral expert can weigh on that. So there is an issue, there is a mechanism to resolve these issues that come up. And but the resolution can only be done when you appreciate the compromising balance that the treaty gives us, and as it was done in 1960. So bridging the gap is only possible when we empower the Permanent Indus Commission as well to take more decision, to table issues in a quicker, more efficient fashion, and for both countries to go use the effective dispute resolution mechanism. Stepping out of the treaty is just going to widen the gap, not narrow it.
Now we know that Indian stance, which is rooted in politics, the statement by their Prime Minister that blood and water cannot flow together is indicative of a certain mindset. And if the intent is to choke Pakistan's river flow, so all those actions flow from that ideological orientation. India has been moving the goalposts on this issue, first citing climate change, then citing renewable energy obligations, then they have added their population and the agricultural needs, and yet again the issue of terrorism. So where will it all stop, and are those the right reasons? Why don't they share their concerns within the framework of Indus Water Treaty that Pakistan has been continuously insisting upon, that they have shied away of discussing and convening the Indus Water Commission? Because unless you discuss within that, how would we know that climate change results in surfeit of water or shortage of water? And what is the intent of India?
So at the outset, and I've written a lot on this, India is saying that there is something that the Vienna Convention on the Law of Treaty says, a fundamental change of circumstances, which particularly is a legal concept in international law that says that sometimes after a treaty has been signed, the situation changes so fundamentally that it renders the treaty obligations obsolete or unreasonable. But at the same time, it's important to understand that no treaty in modern times has been set aside because of the fundamental change of circumstances. And there's a reason for that. The reason is that the threshold of what will be a fundamental change is so high that it's nearly impossible for there to be something that reaches that. And the International Court of Justice has already weighed in on that. So in a case between Hungary and Slovakia, which was also for on the building of a dam, the courts said that even the change of a political government or the complete change of a country's administration would not qualify as a fundamental change. When we talk about India, what they're saying is a fundamental change. Number one is climate change. Climate change is not a fundamental change because it was very foreseeable that the climate was changing in 1960. Global warming had become an issue at that time as well. There are multiple reports by independent international organizations, if we go back to their archives in 1960, that was happening. Population. When you talk about population, India's population already had been from the 1940s till the 1960s had increased, and there surveys by the Indian government that show that they were preparing for a population expansion. So now coming and saying that, oh, population is a fundamental change. A fundamental change needs to be so unforeseeable that at the time that the treaty was signed, it could possibly not be on the horizon of either party. And the third is sustainability, and that there's nothing to stop both countries from collaborating on sustainability within the framework of the treaty. The Permanent Indus Commission is empowered to deal with all issues relating to the sharing of the treaty. We can empower the Permanent Indus Commission, have sustainability, climate change experts within that commission who can help maneuver that. Multiple countries around the world are working on sustainability within existing international legal frameworks, and it's working fine. There are multiple international organizations that particularly work on transboundary waters and how to include sustainability. Their work has enough research to shed light on this. So so for India to now say that, oh, it's a fundamental change, that is absolutely incorrect, and there's no way they can justify that on a legal basis.
Okay, that's clearly understood. Now you see that India has been creating facts on the ground. The holding of holding back of the treaty. And there was a long pause in the process.
Yes, sir.
From, I believe, 2013 onwards?
16 onwards. Yeah. December 16.
December. And India used that pause to create facts on ground, that is, complete its Kishan-Ganga Dam project. Now, they have walked out of the treaty. And they say that they have not abrogated the treaty, which they cannot, according to the terms of the treaty. They have actually held it in abeyance. And they are not cooperating, they are not discussing, they are not sharing the river flow data with Pakistan. In such conditions, if they keep constructing dams, pondages, and to an extreme level, if they start diverting the river waters through the gravity canals, which is maybe technically feasible, near Akhnur, there are locations they can take. It's difficult in Jhelum and Indus, but maybe possible with the river Chenab. If they take out those gravity canals, if they make those bigger pondages which threaten the water security of Pakistan, which is already a water-stressed country, would we be justified in considering that as an act of war and respond?
So that's a very interesting question. Till date, the creation of new projects on shared waters has not led to it being declared as an act of war. However, just because something that has not happened till date does not mean that in future situations can't evolve accordingly. What we need to understand is that water is a lifeline for Pakistan. There are no two ways about it. It's part of our everyday sustenance, it's part of our security, and most importantly, the right to water is a recognized human right under the United Nations Charter now.
But not enough casus belli to start a war.
But I have a different view on that. I think that if the diversion or the stoppage of water is going to threaten the entire existence of a country, that is tantamount to armed aggression. Because what the idea is that philosophically we look at it, what does a war do? A war aims to annihilate an entire nation. That's exactly what a lack of access to water can do to Pakistan. We're an agricultural economy. We cannot.
So it can be construed as an act of war, and yes, Pakistan reserves the right to respond using all elements of national power, not necessarily the armed instrument, but other instruments as well.
For sure, sir, it does, because the idea is that it's threatening our sustenance for the existence of the people of Pakistan.
Great. And now coming over to specific Ratle and Kishan Ganga, which is still going on. Now, in the light of this latest award by Court of Arbitration, which has emphasized that each issue or dispute would be considered on its own technical merits. Neutral experts have a certain constrained model to adjudicate. Court of Arbitration is a little more expansive. Now, in case of Kishan Ganga and Ratle, parallel process is going on. So how would that pan out in your reckoning?
So parallel processes have happened in international law in the past as well, and the way that they in a couple of cases were brought before the ICJ, the ICC, and committees of the UN simultaneously. The way that works is that every judicial body gives its own gives its own judgment, while at the same time respecting the judgment or taking into account the judgment of the other ones. For instance, in the climate change proceedings in the ICJ, the court took into account what the Inter-American Court had said on the issue. But the particular issue with Indus is a bit more difficult, because it's the same issue that is being dealt with by two, and the issue then is what happens if there is a conflicting opinion between the Court of Arbitration and the neutral expert. And that situation has never arisen before. But what my take would be that a conflicting opinion in itself would be a new dispute. And that because the conflicting opinion would be a new dispute, you can then take that conflicting opinion to another court of arbitration and then ask the court to rule on the legal issue that what will happen when there will be a conflicting opinion. So because the issue would still be of an interpretation of the treaty, the Court of Arbitration is equipped to deal with interpretational issues, and so you can still take it to the Court of Arbitration. I do not think that conflicting opinions will make the treaty dysfunctional. I just think it's going to add another layer to the dispute resolution mechanism in this particular case, which is going back to a newly formed Court of Arbitration for this particular legal issue.
Maham, last question. It's a de facto position that treaty is being held in abeyance by India. It's not cooperating either with Court of Arbitration or neutral expert. Now, under these conditions, what are the legal and diplomatic options with Pakistan to bring India back to the fold of Indus Water Treaty?
So on the legal options, there are two main ones that I think would be the most effective. The first is the ICJ. The ICJ has jurisdiction in two kinds of cases. One is an advisory jurisdiction and one is a contentious. The contentious is where the state versus state cases are dealt with, and we can't go, there's no jurisdiction to go to the ICJ for that. But on the advisory jurisdiction, in which international organizations can ask the ICJ for advice, there's nothing stopping Pakistan from rallying support for the World Bank, the United Nations General Assembly, or the United Nations Security Council to ask the court for an advisory opinion on the status of the treaty when one state has unilaterally kept it in abeyance. When we talk about the Security Council, this is an issue for international peace and security. Pakistan and India are both nuclear armed countries. One country threatens the lifeline of another country. I don't see a bigger international peace issue than this. So the Security Council could be seized of the matter. The same is the case with the General Assembly or the World Bank as a signatory to the treaty. And the World Bank, although has on multiple occasions said that their role is only procedural and logistical in nature, but still, it is when you look at the first page of the treaty, it's one of the signatories. The World Bank could be pushed to go to the court for an advisory opinion. That is one of the legal options that we can see. The second legal option that Pakistan can exercise is going to international committees, and because there are a lot of organizations talking about water and environmental, those are soft law options, but still have a recommendatory nature. And if the international water law, this is also an international human rights issue for us, because water is a human right. So there are human rights committees that could be approached. On the diplomatic front, Pakistan should firstly make its stance very clear to the international community of why Pakistan is saying what it's saying. For instance, when you talk about the fundamental change of circumstances, it has to be very clear in legal terms why the legal case that India is trying to put forward is incorrect. Our ambassadors around the world should be doing that. The second is engagement with international organizations as well. Again, there are so many organizations working with water and environment, and it's important to get them on board and to explain to them what our stance is. And the third thing that Pakistan can do is that Pakistan can frame this as a transboundary water issue that will become a precedent for other transboundary issues. There are more than 100 transboundary rivers around the world, and like we were talking about Egypt, Ethiopia, whatever happens on one river will kind of be used as an example on other rivers as well, right? So this needs to become a global debate of river rights.
Yes, because of this, because our watersheds, our river basins, they are interlinked. The need for joint watershed management, sharing of hydrological data, telemetry, real-time exchange of information through something like SCADA means to ensure that this distrust is minimized. Thanks, Maham, for a very succinct and concise discourse on a very contentious and complicated topics.
Thank you so much, sir. Thank you for having me.